Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Workers' compensation is a form of insurance providing wage replacement and medical benefits to employees injured in the course of employment in exchange for giving up the employee's rights to sue his or her employer in civil court. Social Security disability insurance is a payroll tax-funded federal insurance program. It is managed by the Social Security Administration and is designed to provide income supplements to people who are physically restricted in their ability to be employed because of a notable disability. Our guest today is attorney Ron Foster, Jr. He is with the firm Schoen Walton Telken Foster. Mr. Foster has focused his practice to representing Illinois and Missouri clients having claims for personal injury, workers' compensation benefits, and Social Security disability benefits. He has litigated civil cases in both state and federal courts, cases for injured workers before the Illinois Industrial Commission and the Missouri Division of Workers' Compensation, and before the Office of Hearings and Appeals of the Social Security Administration. Today we're going to learn the basics about workers' comp and Social Security disability. Ron Foster, welcome to Conversation.
Thank you for having me.
I'm glad you're here today. These are two very complicated subjects, obviously, since attorneys are usually recommended in cases like this, are they not?
Yes, they are. Attorneys are recommended to represent individuals that are either injured on the job or that have sustained a disabling disease or condition before the Social Security Administration. I feel that anybody that's in that predicament should retain counsel and obtain legal advice pertaining to his or her own particular circumstances. So today, what I'm going to be giving hopefully is just general information, but for anybody watching, I would highly recommend that each consult their own attorney regarding their own situation.
Is this something, either workers' comp or Social Security disability, are people who are not trained in law even capable of even taking the first steps?
Well, I would say with regard to workers' compensation, just to kind of focus on that for a second, I believe that the worker should have certain knowledge in order to proceed with the case. In Illinois, for instance, there is a notice requirement that they have to give to the employer after they become injured. That notice requirement is within 45 days of the injury. Now, the notice could be something as general as a witness who's a supervisor to the incident, or in a case where there is no incident that's witnessed, then the employee should go to the supervisor and report the incident. Aside from that notice requirement, I would recommend that they do obtain an attorney, because my experience has been that the workers' compensation litigation is a business. It's a business where you have insurance companies that are basically the ones that pay the benefits to the employees that are injured, and they have highly trained people working for them. They also have doctors that they can retain to do certain exams that really disadvantage the employee. I kind of equate it to a loaf of bread. Actually, I learned this through a defense counsel early on. He said, Ron, the employee wants the whole loaf of bread. It's our job to basically slice it off each time. We're not going to give them the whole loaf of bread. That would be all their benefits that they're entitled to. But we're going to give them a slice until maybe they might get the whole loaf, maybe not. So sometimes employees who represent themselves believe that they got the whole loaf of bread, whenever in fact they did not. Mm-hmm. So I recommend always that they seek counsel, because there are certain rules that you have to abide by with workers' compensation.
And not every attorney is trained to work on workers' comp or Social Security disability, are they?
No. You kind of get a niche in your practice area. In essence, general practitioners, there's not that many out there that I know. People don't really dabble in workers' compensation, it's been my experience, or in Social Security disability cases. I think that what you should look for if you're John Q. Public out there, somebody that has expertise in these two areas of law, because I think those are the type of attorneys that are going to represent your interest to the fullest. I think that if you go to somebody that primarily practices in family law or estate planning, and you want them to handle a disability claim or a workers' compensation claim, you're probably not getting the full benefit of...
You're getting a learner.
You're getting a learner,
Right.
That's right. You're getting a learner on the job as opposed to somebody who specializes in that area. And the laws are continuing to change, especially in the realm of workers' compensation. Within the last decade, we've had 2 overhauls of the Workers' Compensation Act. So you have to be on top of that. Also with the case law and the continuing legal education that you should be attending and that you do attend whenever you're focused in certain areas. Of workers' compensation and Social Security disability. So you're really getting the benefit of somebody that really knows the ins and outs and is on top of the law, so to speak. And then you're also getting a benefit of somebody that actually goes through the trials and litigation with regard to both areas of law. You want to find somebody that's been to trial for a workers' compensation case. You also want to find somebody that's been before the hearing board of the Social Security Administration and been through a trial, because there are certain avenues and certain rules of evidence which must be adhered to, and there's also certain standards and burdens of proof that the attorney must meet in order for his client to be successful in each of those areas.
Mm-hmm. Now, I was surprised when I was preparing for this interview with you, I was surprised to learn that it was as late as the mid-19th century that laws first started to come on the books to protect employees. Apparently before that, if you were injured, the owner of a company just say, well, we can't use you anymore, goodbye. That was the end of their responsibility to that employee. And then there were some laws that started to appear in the United States that said, hey, employers do have certain responsibilities to injured workers. And then I learned that it wasn't until, 1902 or 1905 that the first states began to create the idea of workers' compensation, which was a long drawn-out process. You want to take it from there?
Sure. Just a little history of workers' compensation, at least here in Illinois in particular, and how it came about. Before the Workers' Compensation Act came into effect for the different states, and just so everybody's familiar, each state has its own separate laws pertaining to workers' compensation.
This is not a federal case.
This is not a federal. I'm talking
case.
Specifically about state workers' compensation laws. So, for instance, here in Illinois, we adopted it, and people would probably be surprised, in 1912, I believe, was the first time workers' compensation came into effect here in Illinois. And the reason why workers' compensation came into effect was before workers' compensation, if you had an injured worker on the job, he or she would have to present a civil claim before a jury trying to prove negligence against the employer to some extent. That posed various problems. One, you had to have something that occurred where somebody else was at fault, namely the employer. So if the injured worker was at fault for his own condition, there was no recovery. The other problem with having civil litigation is that there are also certain defenses that the employer could assert prior to the Workers' Compensation Act. And that would be contributory negligence on the part of the employee, assumption of risk on the part of the employee, and in some instances, if it was a co-employee that caused the incident, they can avoid liability altogether.
Define co-employee.
Co-employee would be if you and I work for ABC Corporation and we're both working together, and let's say you're driving a forklift and I'm standing there and you strike me. You could, obviously I'd have a case against you, or if you assaulted me on the job.
So it's two people who work for the same company.
Same company, correct. Right. So that could absolve the employer of liability in a civil sense.
So then you'd have to sue me.
Right. In essence, I'd have to sue you directly.
And if I had nothing.
And if you had nothing, then the employee recovered nothing. So on the reverse side, before the Workers' Compensation Act, what occurred was if I did sue the employer, if I was successful, those cases could bring pain and suffering, which could result in fairly large and significant verdicts against the employer, which exposed them to greater damages. So the Workers' Compensation Act came about to kind of resolve both of those issues. The employee benefits in that he has to go into an administrative hearing. Just so everybody's aware, the Workers' Compensation Act is a statutory creature, meaning it's made up by the legislature. And what it is a hearing before an administrative board, basically, an arbitrator, so you don't have a jury trial. And during this process, what the employee has to prove is that he was injured on the job, there was an accident, and it was arising out of it in the course of his employment, he became injured. Now, over time, that standard through case law is not as easy as it sounds. There are certain other problems that can arise that I could get fairly detailed, but just to keep it basic for now. If the employee is able to say that he was injured arising out of it in the course of his employment, typically he can say he has a workers' compensation claim. The employer benefits from the Workers' Compensation Act in that there are certain caps, I guess you could call them. There's only a certain amount of money that can be given underneath the Workers' Compensation Act, so you're not going to get pain and suffering.
So it's not like you're going to win $100 million from the employer in a civil case under workers' comp.
Right, so there's a benefit for both underneath the Workers' Compensation Act, the employer and the employee. And I can tell you right now in Illinois, the simple benefits that, in the most simplest way to say it, are that you can receive are you should be able, if you're injured and you can prove your case, that you're injured on the job, the employer should be paying your medical benefits. They should also pay for any time off that you're missing from work as a result of a doctor taking you off work. That's called temporary total disability, and that pays at a rate of 66 2/3% of your average weekly wage.
I was going to say, you're not getting 100% of your money.
You're not getting 100%. You're getting 66 2/3% of your average weekly wage for the time period that you're missing work as a result of a doctor taking you off work. So you can't.
Is this taxable in the same way as regular income?
No, not the temporary total disability, and I think that's why the legislature reduces it down to 66 2/3%, although that's a fairly hefty tax rate, but that is.
So you're still getting close to your after-tax.
Correct, that's the goal.
Pay.
The goal of the workers' compensation system, just so we understand too, is to try to get the worker back to a position he was prior to this incident. So aside from the temporary total disability and medical benefits, the other thing that the Workers' Compensation Act provides for the employee is permanent partial disability. So if the worker is injured, the actual injury itself has a value to it. And that value is predicated upon what body part was injured, or if there's multiple body parts injured. And it's difficult sometimes.
Is this the legislature who set that particular, your right arm is worth so much, your left leg is worth so much, or is that the arbitrators that are saying this?
The maximum amounts are set by the legislature.
So it's in the workers' comp rules.
Right, it's within the statute. You can read each body part, the maximum value attributed to it. Now the arbitrators, if you go to a hearing before the arbitrator, a trial so to speak, the arbitrator actually awards a percentage of that maximum amount under the permanent partial disability portion of the Workers' Compensation Act. So your body as a whole, let's say you injured your back, maximum is 500 weeks. Depending upon the injury, an arbitrator is going to award a percentage of that 500 weeks based upon the permanency of the condition.
Well, let's be specific. I'm right-handed. A machine takes my right arm. What's that worth?
So the arm is worth 253 weeks, I believe, maximum. So that would be an amputation. So if it took your right arm, I don't want to get too mathematical here, but in order to calculate out the permanent partial disability, what you would have to do is take 60% of your average weekly wage times the amount of weeks that are claimed to be permanently partially disabled, and that will give you the value.
So the arm is really dependent upon how much you're being paid.
Correct. In fact, that causes some, discontent amongst some of the clients because they may be working or know of another guy on the job who maybe worked there longer, has the exact same injury, and of course they always talk on the job site, and that particular guy may have told him, I got, X number of dollars for my settlement at the same percentage that the other employee may got that may have just started working at a lower rate, and unfortunately because the rate's less, that employee will recover less for the permanent partial disability. So it is predicated upon the amount that the employee is actually receiving from the employer at the time of the accident. And that's calculated at a rate, your average weekly wage is based upon 52 weeks, excluding the week actually right before your accident occurred. So it's that average. And if you haven't been there for 52 weeks, then there's other methods to calculate that out based upon the time period that the employee worked there.
That's very interesting, that because somebody who's working like in the aircraft industry and making, whoever knows, 40, 50, $75 an hour versus somebody who loses an arm working for a department store or something where they're making $8, $9, $10 an hour, that same arm is worth different.
Right.
A lot different, actually, in those two cases.
Right. And as a practicing attorney, I can tell you it sometimes becomes difficult, whenever you're trying to explain this to clients, because it's hard for them to understand, how this is predicated upon the average weekly wage. But that is the system that we work here in Illinois.
Do you find that most employees or very few employees understand, before they're injured, what the rules are and that they are not going to be able to sue their employer in case of an accident?
I would say for the most part, well, first, every employer has a duty to inform their employees of the rights and remedies underneath the Workers' Compensation Act, whether it's posting a poster or giving out a handout. I believe that they should have something up in the place of employment describing, what rights they have.
That presumes anybody's read anything. But
exactly. I would say, if you're asking me percentages, I'd say for the most part, employees don't know what their rights are.
So most of your clients come and go like, what? Is that kind of the reaction?
Yeah, for the most part, they do. Then you have your more savvy ones that do know their rights and know the Workers' Compensation Act pretty well. Now, I'd say that for the most part, the reason why I say most don't know is because here in Illinois, one of the most beneficial things that an employee can do is see a doctor of their own selection. Which is a given right underneath the Illinois Workers' Compensation Act. And that is a special right that every employee should undertake and utilize.
Is that not the same in Missouri?
It is not the same.
And you do practice in Missouri,
I do practice in Missouri as well, and I've tried a case over there too. So what I would say is the difference in Missouri is that the employer selects your physician. And believe me, it's a big difference. Now, the reason why I say my experience has been like a lot of clients don't understand their rights here in Illinois is because sometimes I will see the client, and what's happening in most of the instances is the employer in Illinois is directing the care and treatment because the employee is essentially waiving their rights unwittingly, which causes quite a few problems in the area of workers' compensation, especially when you're talking about return to work or maybe needing to be referred out for an MRI or maybe needing to be referred to a specialist, because certain doctors employed by the employer have their own opinions, but like I said before, it's a business. But I think for the most part, my experience has been the doctors they retain are very leaning on the conservative side of treatment and don't seem to go the extra expense or the extra mile, in my opinion, that a doctor would, that you would select, that you already have a relationship with, that you're familiar with, to give you care and treatment. And that's why I say a lot of employees, I don't think, know their rights, because if they did, they would certainly be utilizing that right to select their own physician, because that's a big one.
Let's move on to Social Security disability. That is a completely different animal than what we've just been discussing, right?
Right, it is. That is actually two programs. One is Social Security Disability Insurance, and one is Supplemental Security Income, both under two different titles underneath the underneath the Social Security Disability Act. Now, in order to receive Social Security Disability Insurance, which is actually the better of the two programs, you basically have to be insured. In order to be insured, you have to have paid certain amount of quarters in order to receive that insurance. I think in the last 10 years, you'd have to pay quarterly 5 years. I think it's 20 quarters that you have to.
Are you talking about through the deductions that they take from
your wages?
Right,
correct. So that's basically insured.
So that FICA part.
Right.
So you had to be there a certain number of FICA months in order to be insured,
correct. And that affords you Title II coverage, which is the better of the two coverages. And that comes through the amount of money that's basically taken from the taxes. And basically workers who have become injured, most all are insured and have Title II coverage, which is good. Now, supplemental security income, that's for people that didn't pay enough into the system to be insured underneath Title II. Mm-hmm. So for that, that could be children that become disabled, or in a lot of cases, what I've represented are people with mental disabilities that haven't been able to hold a job long enough to pay quarterly, that need to get on disability. So
you're saying people in our society who maybe 22 years old, never held a job, that they can actually be paid a certain amount of income through Social Security disability? Is that what you just said?
Right, but it would be underneath, they call it the Supplemental Security Income as Title 16, underneath the Social Security Act. There's two different basic chapters that I'm talking about. So the disability insurance, which is the better program, that's Title II. The Supplemental Security Act, that's Section 16. That will cover people who haven't paid into the system. Now
under Title II, which I guess those are just regular workers, people who have been working and get injured, and they have now a catastrophic injury, they might be getting workers' comp too, right? Or is this additive, or is it an either-or situation?
No, this is how it kind of works, and this is why I practice in both areas, because I want to go back to workers' comp for 1 second, because aside from the permanent partial disability, you can also get permanent total disability and also a wage differential claim. And the reason Social Security comes into play is sometimes clients are permanently totally disabled due to a terrible injury on the job. Mm-hmm. And by totally disabled, I mean they're not able to return to any type of work. And that's
they're wheelchair bound and
right, or
maybe blind or something.
Yeah, and sometimes just, given their age and their skills, and they've gone through vocational rehabilitation, which is also a cooperative effort and also afforded underneath the Workers' Compensation Act, this person just can't find a job. Mm-hmm. And in those situations, as a practitioner, what you want to start looking at, when you start to realize you have a client who's probably not going to make it back to work, to file the Social Security disability claim. And they do work together, and you have to know the rules and how they interplay, because that's important. If you have an injured worker and he's getting permanent total disability, and that could be 66 2/3% of his average weekly wage, and you want to settle the case, you can do that on a lump sum amount. But what you need to be wary of is that if you've applied for Social Security disability, and if in fact that person gets on Social Security disability, meaning Social Security, gets an offset to what's being paid by comp. And that offset is you cannot receive more than 80% of your pre-disability amount than by receiving both benefits. The best way I can explain
So the feds will pay you, your workman's comp you said was 66 2/3, and then the feds will pay you up to 80, and that's as far as it'll go.
Right, and what you want to be careful of is and the reason why I'm using the lump sum amount is because there are certain rules you can do to help this out. So going back to that, let's assume before you became disabled, you're making $4,000 a month. Mm-hmm. Then let's assume on disability, you're making $2,200 a month. And then assume you're making $2,000 on workers' compensation. That's more than the 80% of your pre-disability income. So what Social Security will do is they'll see that $2,000 and they'll say, okay, 80% is $3,200, and they'll reduce their payment by $1,000. Right. So the problem becomes, if you want to do a lump sum settlement underneath the Workers' Compensation Act, what can happen if you don't structure it correctly is disability will look at that lump sum amount and really stop or reduce your client's payment of the disability, saying, hey, you have to pay down your benefit, because they will continue to use that offset until that amount of the work comp runs out, or you reach 65 where you can retire. But what you can do in workers' compensation when you settle the case is you can take that lump sum amount and utilize language to spread it out over that employee's lifetime to help create less of an offset taken by disability. so you can maximize the amount that your client is getting for his or her pocket for disability, yet simultaneously allowing your client access to the full lump sum amount that you're going to obtain. And that can be significant in permanent total cases.
Hence the experienced attorney versus the learner attorney. And by the way, we have about like 3 minutes left here. So what I want you to cover is, in this last 3 minutes, is what do you want people to know at this point?
Okay, as far as what I'd like people to know is that if you're injured on the job, especially here in Illinois, you know, I would say make sure you retain counsel. The employers are working very hard to minimize your recovery. Employees now, although we talked about the Workers' Compensation Act and how it benefits both employers and employees, employees still suffer some, you know, sort of a detriment through the Workers' Compensation Act, whether it be conflicting medical opinions, stopped TTD payments where they're not getting their weekly check. Private investigators get hired to follow these people to try to come up with something showing that they're doing something beyond their restrictions.
They're out playing football.
Right.
Yeah.
They're trying to catch them doing something, invading their privacy. You know, you're dealing with sophisticated people, and I think your best avenue is always to retain an attorney to help represent you and guide you through some of these potential loopholes. And, you know, some of the loopholes are new case law that says if you're injured on the job and you're not exposed to that of a greater danger than that of the general public, you're not going to recover underneath the Workers' Compensation Act. A lot of employees don't know that. So you have to be cautious in how you approach each case. Also, if you sustain a serious injury and you're looking to file both workers' compensation and Social Security disability, you should retain an attorney for the one issue that I talked about, and that's spreading out and trying to maximize your benefits. The other one is you have to be cautious about Medicare, because once you're on disability, you become Medicare eligible underneath Part A and Part B within 2 years. And if you have a workers' compensation claim, the Medicare rules say that you have to account for their interest. And a lot of times when you're resolving,
Account for what?
You have to account for their interest for payment of the injury from the workers' compensation case. So what that means is essentially you have to try to figure out what the future medical costs are going to be. You have to gather that and submit it to Medicare for approval. If they approve that amount, it goes into a Medicare set-aside trust, and that money is only to be utilized for the actual work injury. If you fail to set up a Medicare set-aside trust, you could get in trouble with Medicare whenever you're needing treatment for your injury, and Medicare realized you didn't set up a proper trust or you didn't account for their interest, and now you're in a position where you may not have any type of coverage. So that is paid in addition to the permanent total disability or the other benefits that I talked about. But Medicare is a huge issue, especially on those catastrophic injury cases.
Boy, we've covered a lot here in 30 minutes. Thank you very much for being with us. Have to have you back, and we can talk in more specifics about that and talk about some other side issues involved in both of those programs. Thank you very much.
Okay, thank you for having me.
And I've been speaking with Ron Foster, Jr. He is an attorney who specializes in workers' comp and Social Security disability insurance programs. This is going to be uploaded to YouTube, so if you want to show it to other people, just go to YouTube, look up Conversation with Lee Presser, Ron Foster, and you'll find it. Thank you. See you next time.